Imagine waking up tomorrow to find out that every single assault weapon ban in America has been struck down permanently by the Supreme Court. And that's not just some far-off dream or wishful thinking. That is potentially about to become reality because of a major development that just happened at the Supreme Court. And this could change everything when it comes to the Second Amendment and your right to own the most popular rifles in America. So let's talk about this breaking development and what it means for gun owners across the entire United States. Now, before we jump into this critical update, I want to thank the sponsor of this video, which is Silent. Let's face it, in today's world where our every move is being tracked, our phones and laptops are essentially just surveillance tools in our pockets. Big tech companies, government agencies, and yes, even cyber criminals, they're all collecting massive amounts of data on us through the devices that we carry every single day. That's why I personally use Faraday bags and other privacy protection tools, and I highly recommend Silent and their Faraday gear. These bags and other items block all wireless signals, cellular, Wi-Fi, Bluetooth, GPS, RFID, and all those other signals that hackers and government agencies use to track your location and get into your devices. I use their backpack literally every single day when I'm going to and from the office. I put my laptop in there, my phone in there, and I also use it extensively when I'm traveling through airports or when I'm staying at hotels because I want to make sure that my devices are protected. This is especially critical right now as these legal battles heat up because the digital footprint of gun owners is being tracked more aggressively than ever. When you search for information about the Second Amendment or rifle parts, that data isn't just floating in space, it's being harvested. So if you're interested in protecting your privacy, your freedom, and all of your family's devices by simply using a Faraday bag, I highly recommend Silent. You can go to silent.com or Scholar and you can get 15% off and free shipping as well on all of these products. As I mentioned in the intro to this video, we're going to be discussing a breaking development at the Supreme Court that could potentially end all assault weapon bans across the United States permanently. Now, this is something that we have been waiting for years. This is something that Second Amendment advocates have been calling on the Supreme Court to address ever since they issued their landmark ruling in New York State Rifle and Pistol Association versus Bruin back in 2022. And now, finally, it looks like the Supreme Court might actually be ready to fulfill that promise and take up this critical issue. So let's break down exactly what happened, what this means, and what we can expect moving forward. The case that we're going to be talking about today is Harrell versus Rowell, and this is a case that challenges Illinois' statewide assault weapon ban. And just recently, the Supreme Court took a significant step forward with this case. They didn't grant cert yet, but what they did do is they called for the views of the Solicitor General, and that is a huge development. Let me explain why that matters so much. When the Supreme Court requests the views of the Solicitor General, or what's called a CVSG order, that stands for Call for the Views of the Solicitor General. That is often a strong indicator that the Supreme Court is seriously considering taking up the case. It means that the justices are interested in the legal questions presented, and they want additional input from the federal government's top lawyer before they make a final decision on whether to grant review. Historically, when the Supreme Court issues a CVSG, there's actually a pretty high rate of the court ultimately granting certiorari and taking up that case. So this is a really positive sign for Second Amendment advocates who have been waiting for the Supreme Court to finally address these rifle bans that have been proliferating across multiple states. Now let's talk about what's actually at stake in this case. The Harrell case specifically challenges Illinois' ban on so-called assault weapons and high-capacity magazines. Illinois passed this ban back in 2023, and it prohibits the sale, manufacture, delivery, and possession of dozens of specific firearm models by name. We're talking about AR-15s, AK-47s, and similar semi-automatic rifles. The law also bans any rifle with certain features like pistol grips, folding stocks, thumbhole stocks, muzzle brakes, flash suppressors, and grenade launchers. You know, all of these features that gun control advocates claim make a rifle more dangerous, even though in reality these are just cosmetic features that don't actually change the function of the firearm. The law also bans magazines that can hold more than 10 rounds for rifles and more than 15 rounds for handguns. So we're talking about a pretty comprehensive and restrictive ban on the most commonly owned rifles and standard capacity magazines in America. But here's what makes this case so powerful, and this is something the opposition simply cannot overcome. The latest industry reports submitted to the court show that the AR-15 is not just popular, it is the standard. As of early 2026, there are an estimated 28 million modern sporting rifles in the hands of American citizens. To put that in perspective, that is more than the number of Ford F-150s on the road. Under the Heller and Bruin framework, if a firearm is in common use for lawful purposes, the government's power to ban it is essentially zero. The petitioners are using this data to force a simple question: how can a weapon be unusual if it is the most frequently purchased rifle in the country? The plaintiffs in this case, and that includes individual gun owners along with organizations like the Second Amendment Foundation, they argue that this ban is a clear violation of the Second Amendment. They point out that AR-15s and similar rifles are the most popular rifles in America, with literally tens of millions of them in circulation and owned by law-abiding citizens. These firearms are regularly used for lawful purposes like home defense, target shooting, competitive shooting, hunting, and just general recreational use. And under the Supreme Court's rulings in Heller and Bruin, firearms that are in common use for lawful purposes are supposed to be protected by the Second Amendment. That's what the Supreme Court said. So if tens of millions of Americans own these rifles and use them for lawful purposes, how can states just outright ban them and claim that they're not protected by the Constitution? That's the central question that the plaintiffs are asking the Supreme Court to answer. Now here's where things get really interesting and why this case is so critical. After the Supreme Court issued its ruling in Bruin back in 2022, we all expected that lower courts would start striking down unconstitutional gun laws left and right. The Bruin decision established this text, history, and tradition test, right? It said that if a firearm regulation goes beyond the plain text of the Second Amendment, then the government has to show that the regulation is consistent with this nation's historical tradition of firearm regulation, and if they can't show that historical precedent, then the law is unconstitutional. Pretty straightforward, right? Well, that's what we thought, but what actually happened is that many lower courts, particularly in circuits like the Second Circuit, the Fourth Circuit, the Seventh Circuit, and others, they basically ignored Bruin. They engaged in what I would call judicial gymnastics to uphold these assault weapon bans despite the clear directives from the Supreme Court in Bruin. The Seventh Circuit's ruling in this Harrell case is a perfect example of this. The Seventh Circuit upheld Illinois' ban, and their reasoning was essentially that AR-15s and similar rifles are too much like military weapons, specifically like the M16, and therefore they can be banned. The court said that these rifles are useful in military service and that makes them somehow different from other firearms and outside the scope of Second Amendment protection. But here's the problem with that reasoning, and this is something that the petitioners in this case have pointed out very clearly. The Supreme Court in Heller specifically rejected that kind of analysis. A massive part of the current breaking development is the court's scrutiny of the term assault weapon itself. In the oral arguments and briefings being pushed forward right now, the justices are digging into the technical differences between a civilian AR-15 and a military M4 or M16. For years, lower courts have upheld bans by claiming these rifles are virtually indistinguishable from weapons of war. However, the 2026 briefings include expert testimony on ballistics and firing mechanics. Unlike military rifles, civilian models are strictly semi-automatic, one trigger pull, one round. The caliber, the .223 or 5.56 round, is actually smaller than many common hunting rounds, debunking the high-powered narrative used by state legislators. Data shows these rifles are the primary choice for hog hunting, predator control, and home defense due to their modularity and ease of use for smaller-statured individuals. The Heller decision made it clear that the Second Amendment protects arms that are in common use for lawful purposes, period. It doesn't matter if those arms could also potentially be useful in military service. In fact, historically, the arms that were protected by the Second Amendment were precisely the kinds of arms that would be useful in militia service. That was the whole point. The founders wanted citizens to be armed with effective weapons that could be used both for personal defense and, if necessary, for militia service to defend the country or defend against tyranny. So when the Seventh Circuit says that AR-15s can be banned because they're similar to M16s and useful in military service, they're actually turning the Second Amendment on its head. They're saying that the more effective a weapon is, the less it's protected by the Constitution. And that makes absolutely no sense when you actually read the text and understand the history of the Second Amendment. The plaintiffs argue that if the Seventh Circuit's reasoning is allowed to stand, then essentially no firearm is truly protected by the Second Amendment, because you could always find some military analog or some way to argue that a firearm is too dangerous or too effective to be protected, and that would basically gut the Second Amendment of any real meaning. Now, this isn't just an Illinois problem. Like I mentioned, multiple circuit courts have upheld similar assault weapon bans in recent years, even after Bruin. The Fourth Circuit upheld Maryland's ban. The First Circuit upheld Massachusetts' ban. The Second Circuit has upheld New York's restrictions. And so we have this situation where in large parts of the country, we're talking about states that contain millions and millions of gun owners. These commonly owned rifles are being treated as contraband that can be outright banned. Meanwhile, in other parts of the country, these same rifles are perfectly legal and widely owned and used without any problems. So we have this massive split where your Second Amendment rights literally depend on which state you happen to live in. And that's exactly the kind of situation that the Supreme Court is supposed to step in and resolve. But here's where 2026 is different from previous years. For the first time since Bruin, an appellate court is on the verge of striking down an assault weapon ban entirely. Legal analysts are watching a challenge to New Jersey's AR-15 ban in the Third Circuit that could change everything. The Third Circuit has recently shifted toward a more originalist bench. If they rule that New Jersey's ban is unconstitutional, it creates what's called a circuit split. When two major courts disagree, say the anti-gun Fourth Circuit, which upheld Maryland's ban, versus a pro-gun Third Circuit, the Supreme Court is constitutionally compelled to step in and settle the matter for the entire nation. That's why this CVSG order is so significant. The Supreme Court is clearly taking notice of this problem. They're seeing that the lower courts are not properly applying Bruin, and they're considering whether it's time to step in and provide further clarification and guidance. Now, I want to be clear, a CVSG order does not guarantee that the court will grant cert and take up this case, but it is a very positive sign. It shows that multiple justices are interested in the legal questions presented and want more information before making a decision. So what happens next? Well, now the Solicitor General will have, typically they're given about 30 days or so, to file a brief with the Supreme Court giving the federal government's position on whether the court should take up this case. The Solicitor General will analyze the legal questions, the circuit split, the importance of the issues, and all of that, and then they'll make a recommendation to the Supreme Court on whether cert should be granted. After the Solicitor General files that brief, the Supreme Court will then consider the case again at a future conference, and they'll make a decision on whether to grant cert and actually take up the case for full briefing and oral argument. Now, here's where things get really interesting from a political and legal standpoint. The Solicitor General represents the executive branch, and we all know what position they're likely to take. But here's the thing. Even if the Solicitor General recommends against granting cert, that doesn't mean the Supreme Court won't take the case anyway. The Supreme Court is not bound by the Solicitor General's recommendation. They can grant cert even if the Solicitor General says they shouldn't, and given the makeup of the current Supreme Court, with 6 justices who at least claim to be originalists and textualists who should be sympathetic to Second Amendment rights, there's a very real possibility that the court could grant cert in this case. Let's talk about what a Supreme Court ruling in this case could look like and what it could mean. If the Supreme Court grants cert and ultimately rules in favor of the plaintiffs, striking down Illinois' assault weapon ban, that ruling would have nationwide implications. It wouldn't just affect Illinois. It would affect every state that has similar bans in place. We're talking about California, New York, New Jersey, Massachusetts, Maryland, Connecticut, Washington, Colorado, and several other states that have enacted these kinds of restrictions. A Supreme Court ruling that these bans are unconstitutional would invalidate all of those laws across the country. We're talking about potentially restoring Second Amendment rights to millions of Americans who currently live under these restrictive regimes. When the script mentions a permanent end, this refers to a categorical ruling. If the Supreme Court issues a merits decision stating that semi-automatic rifles with tactical features like pistol grips or telescoping stocks are protected, it doesn't just pause the bans, it makes them unconstitutional on their face. No more feature bans where states can ban a gun just because it looks like a military rifle. No more name bans where lists specifically ban Colt AR-15 or Bushmaster models. The common use shield would mean that any firearm owned by a significant percentage of the population would be effectively unbannable. Now, the Supreme Court would need to address several key legal questions in order to strike down these bans. First, they would need to clarify that the common use standard from Heller applies to these rifles. They would need to make it clear that when tens of millions of Americans own a particular type of firearm and use it for lawful purposes, that firearm is protected by the Second Amendment, period. Second, they would need to reject this military usefulness test that the Seventh Circuit and other courts have been using. They would need to make it clear that the fact that a firearm might be useful in military service does not take it outside the scope of Second Amendment protection. In fact, quite the opposite. Third, they would need to provide guidance on how the text, history, and tradition test from Bruin applies to these kinds of categorical bans on entire classes of firearms. If the Supreme Court does all of that and strikes down these assault weapon bans, it would be one of the most significant Second Amendment victories in modern history. It would be right up there with Heller and Bruin in terms of its impact. It would fundamentally reshape the landscape of gun rights in America and would restore rights to millions of people in blue states who have been living under unconstitutional restrictions for years or even decades. As the Supreme Court moves closer to a final decision that could end these bans permanently, the political reaction in blue states has reached a fever pitch. We are seeing what legal analysts call the Great Scramble. Governors in states like New York and Washington are already drafting contingency laws. If they can't ban the rifle, they plan to tax the ammunition out of existence or declare every square inch of their state a sensitive place where the rifle cannot be carried. However, the Supreme Court seems to have anticipated this. In the current push forward, Justice Gorsuch has hinted that the court is looking for a comprehensive remedy. This means they aren't just looking to strike down one law. They are looking to issue a ruling so broad that it preemptively kills these workaround tactics. Even as the bans are being dismantled, blue states are shifting to a new tactic: backdoor bans via registration. In states like Illinois and Connecticut, the strategy right now is to say, okay, you can keep the rifle, but you must register every single part, every magazine, and every serial number with the state police. The current litigation being pushed forward by groups like the National Association for Gun Rights and the Firearms Policy Coalition is targeting these registries directly. The argument is simple: a right that requires government permission and tracking is not a right, it's a privilege. And look, I think we need to talk honestly about the Supreme Court's track record on this issue because it hasn't been great. Despite having a 6-3 conservative majority, the court has been very reluctant to take up Second Amendment cases. After Bruin, a lot of us thought we would see the court taking up multiple gun cases every term and systematically striking down unconstitutional laws, but that hasn't happened. The court has denied cert in numerous important Second Amendment cases, leaving bad lower court rulings in place. And that has been frustrating to say the least for Second Amendment advocates who feel like the court is not living up to its responsibility to protect constitutional rights. So the question is this time different? Is the court finally ready to take up this critical issue and provide the guidance that lower courts desperately need? Or are they going to punt once again and leave millions of Americans without full Second Amendment protections? We're going to find out in the coming months as this case progresses. The stakes here could not be higher. We're talking about the future of the Second Amendment. We're talking about whether Americans have a constitutional right to own the most popular rifles in the country. We're talking about whether the Second Amendment is going to be treated as a real constitutional right on par with the First Amendment and other fundamental rights, or whether it's going to continue to be treated as a second-class right that can be regulated and restricted at will by state governments. This is the fundamental question that the Supreme Court needs to answer. And let's be clear about what's really going on here. These assault weapon bans are not about public safety. Study after study has shown that rifles, all rifles, not just so-called assault weapons, are used in a tiny fraction of gun crimes. According to FBI statistics, more people are killed with hands and feet every year than with rifles. More people are killed with knives. So-called assault weapons are used in a very small percentage of gun homicides. The vast majority of gun crimes are committed with handguns. So if these bans were really about reducing gun violence, they would focus on handguns, not rifles. But they don't, because these bans aren't really about public safety. They're about control. They're about incrementally restricting gun rights until eventually the Second Amendment is meaningless. That's why it's so critical that the Supreme Court step in and draw a line. They need to make it clear that states cannot ban entire categories of firearms that are in common use for lawful purposes. They need to make it clear that the Second Amendment means something and that it imposes real limits on what governments can do. Otherwise, what's to stop states from banning handguns next? What's to stop them from banning all semi-automatic firearms? What's to stop them from imposing such restrictive licensing requirements that ordinary citizens can't actually exercise their Second Amendment rights? If the Supreme Court doesn't draw a line here with these assault weapon bans, then there's really no limiting principle, and states will just keep pushing further and further until the Second Amendment is completely gutted. So this is a critical moment. This CVSG order is a significant development, and it gives us real hope that the Supreme Court might finally be ready to take up this issue and provide the clarity and protection that the Second Amendment deserves. But we can't take anything for granted. We need to stay engaged, we need to stay informed, and we need to be ready to support the efforts to defend our constitutional rights. So what can you do right now? Well, first, stay informed. Keep watching videos like this one where we break down these legal developments and explain what they mean. Second, support the organizations that are fighting these cases in court. Organizations like the Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America. These groups are the ones actually filing these lawsuits and pushing these cases forward. They need financial support to continue this work. Third, Contact your elected representatives and let them know that you support Second Amendment rights and that you're watching how they vote on these issues. And fourth, if you live in a state with an assault weapon ban or other restrictive gun laws, consider getting involved with local advocacy groups that are fighting to restore your rights. The bottom line is this: we are potentially on the verge of a major Second Amendment victory. The Supreme Court issuing a CVSG in the Harrell case is a big deal. It shows that the justices are paying attention to this issue and are seriously considering taking it up. Now we wait to see what the Solicitor General says, and then we wait to see what the Supreme Court decides to do. But this is real progress, and it gives us genuine hope that the court might finally fulfill the promise they made to address this issue. In the coming weeks and months, we're going to be watching this case very closely. As soon as the Solicitor General files their brief, I'll break it down for you and explain what it means. And as soon as the Supreme Court makes a decision on whether to grant cert, I'll let you know immediately. This is too important to miss, and we need to stay on top of every development. So, as we get more information as it develops, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and help us reach more people with this critical information. Also, you can check out one of these 2 videos here on the screen that the algorithm thinks that you'll find helpful. But as always, thank you guys so much for all of your support. Jemand, der die Schreibt, jemand, das es anbaut.